Good morning. My name is Cassie McSherry, owner and title agent with Assurity Title. And with me today, Lauren Silvers with Silvers Law.
Hello.
Good morning.
Thank you for joining us.
Thank you for having
Absolutely.
me.
Absolutely. So, I was talking with Marilyn this week too, and I thought it would be fantastic for us to focus on some probate issues with agents as they're starting to list properties. So, and I thought a probate attorney would be fantastic to support us in this. I want to lead by saying I am not an attorney. I am a title agent, and our office does deal with probate real estate contracts often. And recently, in this past week, we dealt with a contract that had to go through probate twice. So the situation was that a father had left a property that was his homestead property to his sons. And from the point that he had passed and it had gone through probate, one of those sons had passed. So, Lauren, I'll let you speak to. I didn't tell you that I was going to bring that up, but of course, they were trying to put it through. There was a contract on the property. We were going through the probate process. The son passed, and then, as you can imagine, the buyer and everyone was upset that there was an additional probate. Can you talk to why that would happen? And,
Yes. So that's so did the son, do you know if the son passed like within a month of his father passing? Was it close together?
it was close, but I want to say it was a little more than that. I want to say it was like a couple, like
So
6 weeks, 8 weeks, maybe.
okay, well, depending on and do you know if there was a will involved? So when there's a will, typically the will have a provision in it to avoid situations like that, where it'll say that their survivors are deemed to predecease them if they don't survive them by so many days, and
Okay.
that's to prevent that situation.
Right.
So right, so when obviously when father passed away, the probate was necessary because the property was in his name, and
Yes.
because the son was an heir
Yes.
and likely didn't have any of his stuff in order, it has to go through probate again. Um,
for, for
to
his interest
for
in
his
that
estate.
property. Yeah.
Yes.
And you bring up will, but that's assuming that they had an attorney set up a will that they had an attorney set it up the correct way versus them just doing their own will, right? I mean, having an
Right.
attorney do a will or a trust is going to be a much better way to do it.
Right. So typically, I don't know. I've seen a few like do it yourself wills. I don't know that they have that survivorship presumption in them, but an attorney will typically put 30, 60, 90 days. Those are the most common numbers for how many days. So if my beneficiary predeceases me before 30 days of within my death or within my passing, then they're deemed to have predeceased me. So I'm sorry I said that. But if they decease within 30 days of me passing, they're deemed predeceased to avoid the double probate. So their share of the property would pass to the other surviving heirs without having to probate that share, if that makes sense.
Yeah.
Yes.
And this
It
and this
does.
person obviously didn't have that in their will.
No, there was no will. So, and the other thing is a will does not prevent a probate.
And
So, regardless if they had a will or not, generally property still needs to be probated. You can avoid probate in Florida with a trust or a ladybird deed. If the remainderman in a ladybird deed survives, then that would avoid probate. And if I say any terms that you guys don't understand, you can let me know.
What is a
I have
ladybird
a-
deed?
So a ladybird deed, that's the slang term for an enhanced life estate warranty deed. And so it's only 5 states of the country do them or recognize them. It's a life estate, but it has an enhancement in it. So the grantor retains all rights to the property. They can still take out mortgages on the property. They can sell the property. They can do whatever they want with the property. They don't need the remainder interests consent to do anything on the property. And upon death, that property will pass outside of probate to the named remainderman. So I can make a ladybird deed for my property to my son during my lifetime with a ladybird deed, and then I don't have to worry about it going through probate so long as my son survives me.
So, Sean, that's a little bit different from joint tenants with rights of survivorship. We see that often when we see people who are not married taking title, and they'll take it in that way. But those people, they can't mortgage the property without the other person's interest and all of that. Those ladybird deeds or life enhanced deeds you see typically when it's like a parent, right, who wants it to go to their children without having to go to probate. And I'm just speaking from the title side, what we see in title. Again, I'm not an attorney, but oftentimes it's a parent who will put the property in a ladybird deed, but they can still sell the property, they can still mortgage the property, all of that. But then if they pass, the property automatically passes to those people with the remainder the heirs.
This is cool. Hey everybody, it's Marilyn. Good morning. Lauren,
Good
thanks for being
morning.
with us today. Good morning. Sorry I'm running late today. So if someone is on a ladybird deed, like for example the son, and maybe this question is more for Sean, for us, would the son be eligible? Let's just say now your son is 30, Lauren, and he's been on the ladybird deed the last 30 years. Is the son eligible to take out a mortgage on the property?
No.
Am I understanding? No. Okay.
He'll own
I
it.
just want to make sure. No ownership interest. Okay, very good. Thank you.
Well, are you saying after my death?
No, before your death.
Oh, okay. Sorry, I misunderstood.
No, because you were talking about how the person can take mortgages, whatever. I just wanted to make sure it doesn't cross the line where the other person. But if you're saying son has no ownership interest, then now I understand. Very good.
Their interest only takes effect.
It only triggers upon death, and you need a death.
Upon death.
Yep.
Okay. Very good. So I guess another question too regarding the trust situation, because you said that was another safe way to avoid probate. Can you elaborate that on, isn't there revocable trust versus irrevocable? What specifically type of trust should help alleviate this?
So any type of trust would avoid probate, so long as the property is actually titled in the trust. I've seen people where they've created trusts and didn't fund it, so it did not avoid probate. So long as the property is titled in the name of the trust, it doesn't necessarily matter what kind of trust it's in, it'll still avoid probate. The most common types of trusts you'll see are like revocable living trusts. But there are so many different types of trusts. Like there's the irrevocable trusts, and those are the two main types, and maybe a special needs trust. But I don't want to get too bogged down in all the different types of trusts there are. But so long as the property is held in a trust, upon the passing of the creator of the trust, the trustee, the successor trustee, or the trustee, if it wasn't the grantor, it has the power to remove that property from the trust and title it to whoever is the beneficiary of it.
And that's go ahead.
Question: is this a cheaper option?
A trust is generally not. So a
No,
ladybird
the
deed.
ladybird deed.
The Ladybird deed is the cheaper option.
Gotcha.
But it's something that, and you all might know this, it's something that I don't usually recommend unless they've paid off their property, because it still can trigger a due on sale clause.
From the lender, you're saying?
Yes, if there's an outstanding mortgage on the property. And that's where a trust won't do that. If you have like a revocable living trust and you want to pass your property to that won't trigger a due on sale clause. So you kind of have to weigh your options in that situation. If you want it done now, if you have a couple $100,000 out on your loan, maybe it's better to do the trust, where it might be a little bit more expensive up front, but then you can be certain that you're avoiding probate. Whereas if you have all that money outstanding on your property, do you want to risk having the note called due?
And one of the agents had a question regarding, can you apply for homestead and still file it in the trust? And yes, you can. So you can, because we have our house titled in our trust, and then we have it didn't affect our homestead exemption. So one thing that comes up from time to time, like I have a buyer went under contract mid-August, locked their rate, did their home inspection, did their appraisal, find out a week prior to closing, oh, by the way, they're dealing with probate, and nobody ever told anybody anything about it. So now fast forward, that was the third week of September, we're supposed to close. Still don't know when it's going to be done. Mid-November, interest rates have now went up a full point, and listing agent seller didn't disclose any of this to our buyer.
Can I speak to that? To
Yes.
the agents. This is what I want to, because it's a title issue, right? You can't sell a property. So if you're an agent and you think that a property might be, a title company should know that right away, because our job is to find out whether the person signing the contract, selling the property, has the right to do it. So a lot of times, agents, I hate to say put the cart before the horse. They know that it's the daughter trying to sell the mom's house. We know immediately, even though we're not probate attorneys, we deal with probate situations all the time. We know immediately whether a property has to go to probate. So if we pull, and we can pull title, we will pull title for agents right from the beginning before you even sign a contract, to tell you who needs to sign the contract. So if it's still in mom's name, or if it's in a trust, or if it's in a Ladybird deed, then we'll tell you. You might, we've had agents think, oh, it's got to go through probate, but it's in a Ladybird deed. It doesn't have to go through probate. Sometimes people don't know what they don't know. So if, if you're an agent and you're looking at a property and you're not sure, I suggest that you go to your title company and say, can you pull title on this and let me know what we need to do? And we can tell you pretty quickly. And Lauren, can you speak? Because there's a couple of different probates, and I'm not an attorney. Lauren can tell you some move more quickly. And it's from my experience, if somebody died without a will, it's their homestead property, they don't really have any other assets, it moves more quickly. And there's kind of a summary, and Lauren, you can speak to that because you're the attorney, but we have experience in that, and those move more quickly. They're about 45, 60 days. And then you have other types of probate that are a little more intensive.
So the short version that you're speaking about is summary administration. And those are available where the decedent has been dead for over 2 years, or the value of their estate is $75,000, and that only includes non-exempt assets. Homestead is an exempt asset. So if somebody has a $10 million home, but they only have $1,000 in the bank, they would qualify for the summary administration. So that is an option. That's going to depend on that kind of also depends on whether there's creditors involved. So sometimes it's common where attorneys don't want to do those if there's creditors involved. However, an attorney is not necessary in a summary. So Florida law requires all personal representatives be represented, by an attorney, whereas summary administrations don't require a personal representative. Somebody can do it themselves. I don't necessarily recommend that, but that is possible. So summary probates can be typically taken care of within a month. I know that there was some questions, or Cassie, you mentioned about how long the probate process takes. And I thought maybe you guys might like to know that probate, a formal probate where there's a personal representative appointed, those can take a minimum of 5 months from start to finish. They can, of course, go on for years. The determining factor in how long a probate takes is generally litigation, whether there's litigation involved.
And that means like heirs that are going back and forth, or creditors that are trying to get paid.
Yes.
Any of those things?
The other thing, so what I wanted to say was, fortunately, that does not prevent you from selling property. So property, you don't have to wait until the probate's completed to complete a sale of a property. That can be done during the probate. The other thing is, like you were saying, litigation can arise from, so I actually just had this about a year ago. The litigation was in this would be probably the only time, one of the few times that would make it difficult, if not impossible, to sell a property in probate, where the property is subject to the pending litigation that's dragging it out. So I had a probate where the deceased person, before he passed away, entered a contract for the sale of property with a buyback provision. And so the buyers to that contract were disputing that provision with the personal representatives. So that was dragging on. And
what's a buyback provision? I can't say it. Buyback provision.
See, what's it for?
Why would a seller even have that as part of a regular purchase contract?
So it wasn't, I think they entered the contract like on there wasn't really, I don't even know if there were attorneys involved. But they entered this contract. The decedent purchased or owned a tract of land that he wanted subdivided, and he sold it to developers to develop it with the buyback provision that he was going to be able to buy back 2 of the lots.
Oh, after it was developed. Okay, got it.
Yeah, I've seen that kind of, yeah.
So yeah, they didn't want to do that. And so unfortunately that created a lot of problems. And obviously that prevented the sale of the property during the probate. But as soon as a personal representative is appointed, which generally takes about a month, that they can list the property for sale.
So a personal representative being appointed, that's like somebody at the courts, not like you, not the, the owner hiring or hiring an attorney, right? Personal representative is somebody that's assigned to like the file in the courts.
So the personal representative is just somebody who's going to administer the estate, like the executor.
It's usually a family member, typically.
Okay.
And that would be the person who would sign the contract. So that's where from the title side, that's where we get issues, is that people who maybe didn't have the authority to sign the contract, and they're not in the position to sell the property yet because the courts haven't determined who the personal representative of the estate is. So as Lauren was saying, once that person's represented, then from a title standpoint, we can move forward with the sale because Lauren's still handling the probate. They set up the estate, and then the property sold to the estate in the interest of the estate. It's liquefied, and then Lauren's still continuing on with her process, and we can wrap up our sale.
So the There are ways, and I don't know from I don't know from your side of things, the title side. Technically, if you are the nominated person representative, there are times where you can act on behalf of the estate prior to getting authority. Once you have the authority, you need to petition the court for retroactive approval. But I don't know. That's probably too messy for the title side.
Now, usually we wait for the court to assign a personal representative and authorize the sale of the property.
I think that's kind of reserved for situations where the person didn't know, and then you're just court asking for forgiveness.
Oh yeah.
So if they have a will and they have a personal representative like assigned in their will, does the court approve that a lot quicker? Then
same, it'll be the same, roughly the same amount of time. Depositing the will with the court does not initiate probate. And the only people that can initiate probate are going to be interested parties. So beneficiaries, heirs, and creditors typically.
Okay.
And the difference between a beneficiary and an heir is a beneficiary is what they're called if there's a will, and an heir is if there's no will.
So there's a question in the chat. So how much does it roughly? I know it's going to be different, like setting up trusts. It could be like less complicated, be more complicated. Rough idea on how much it costs to set up a trust, and then how much does it cost to switch the home from like my name, Sean Miller, to the trust?
So to set up a trust is probably going to range between $3,000 and $6,000. That's going to depend on what attorney you hire and how complex the estate is. Most people don't have complex estates. And when I talk about complex estates, I'm talking about generally people who have taxable estates, which is, I think, 14 million in net worth for an individual and twice that for a married couple. So most people don't qualify for that. But so I would say probably within that $3,000 to $6,000 range. That's, like I said, going to depend on the attorney that you get. To transfer the property into the trust, again, kind of depends on the attorney you have, whether they're going to include that in the flat fee for the trust preparation or if that's an additional cost. Deed prep for an attorney is probably somewhere between $200 and $400 per deed, and then plus the cost to record.
Okay. And then do they have to pay doc stamps, Cassie?
Transferring into a trust is generally exempt from doc stamps.
Okay.
Pay 70 cents in doc stamps.
So if they already have a trust set up, it's best to give that the trust docs to the title company, do an addendum to put it in the name of the trust when you're doing the contract, and then you don't have to deal with it after the fact.
Right. Typically when you're taking it out of a trust, you'll the trustee will record, and this is after the trust maker has passed away, they will record the portions of the trust, not the entire trust, but specifically the portions of the trust that give them the authority to make that transfer.
Are the people at any more risk, like financially? Like, and I mean, if you got like all your assets titled in a trust, you got like the real estate that you own titled in a trust, are you at more risk? Like if one of those is like a Airbnb property that you have titled in the name of the trust, are you at more of a risk?
Depends on the type of trust, but if we're going with the most common, which is a revocable living trust, yes. And depending on the situation, if it's an Airbnb, I'm probably going to advise my client not to put that in that trust and to either set up an LLC or a separate trust entirely, like an irrevocable trust. Most people don't like doing that because they have to give up legal title to the property. But in that situation, if you commingle that with your other trust assets, if something were to happen on that property and there was a claim of liability arising from a tenant or a renter, that opens up all of your assets in that trust to that claim of liability. If you have it like in an LLC, it gives you added layer of protection, because they would have to pierce the corporate veil, in order to reach you personally as the business owner, which typically to do that rises to gross negligence.
I had another question.
Sure.
And this, I guess, is maybe more related to the lending side of things again. But with refinances, Sean, like cash out refinances, there's usually like the 6-month ownership period. So with the ladybird deed or any probate, do they have immediate access to do cash out refinances in these two situations?
I mean, I would think transferring it from like if they're sole owners, if it's an LLC and going to their personal name, I would think that they could do it right away. If you're
No,
switching it from their
sorry.
personal name to a trust or a trust back to their personal name, I would
No.
think they can do it right away.
No, I mean like probate, someone dying. So probate, in the probate, we're in the process of probate and I'm taking over the house from my mom. Can I immediately cash out, refinance it? Or do I have to have that 6-month ownership history to be able to cash out, refinance it?
I would think
When can
yeah.
I access my equity?
I would think
is
you'd
the
have to wait.
question.
I would think you'd have to wait 6 months if you're inheriting the property from when you inherit it to do a cash out. If there's any other lender people from our company on here that know the answer to that, I'm pretty sure that's the answer.
Yeah, I think you're right. There's a 6-month seasoning on that.
For a cash out, you could do a limited cash out, I would assume right away to pay off like their parents' mortgage. I would think you could do that before 6 months, but cash out, I would think 6 months. Thank you, Kevin.
Okay, and then yeah, thanks, Kevin. Same thing with the ladybird. If I just took over, the ladybird just took into effect because my mom just passed. Same thing. Do I still have the 6-month seasoning period?
I would assume yes.
Okay. I was just wondering. So
yeah, let's
cool.
double check that with underwriting if you
yeah,
have that
let's double check
situation.
it. Okay.
I would imagine that's true. What they just confirmed, because you have no ownership interest in that property until mom passes. If it's a ladybird deed.
And the ladybird deed, is that something that you would have, like Cassie, I heard you both talking about with that, they typically own the property free and clear, typically. So that's something that they either do like after the fact, or if they're buying the house cash, could they do it at the time of closing?
Yeah. Yes. Yes. They can take title. Well, you're talking about, well, it's something that we can do at the time of closing, or you can do after. So we can do a deed. We have to be issuing a title policy at the time. So we can do the warranty deed and then have the ladybird deed as well. A lot of times it's part of the attorneys do it though, as part of an estate or, but for us from the title standpoint, I was thinking initially, what I was thinking about is at the time that the parent passes or whoever, it doesn't have to be a parent, that's his situation, it automatically transfers. So from a title standpoint, they would be in ownership for your purposes for financing. So there's nothing more that we need from the title side. It would automatically show vesting from our side. All we would have to submit is the death certificate of whoever the parent or whoever. That's all we would need for the transfer of there would be no other deed needed.
Well, this was awesome. Thank you very much for joining. Let's definitely, do this like, another, and we don't have to do it every time that you speak, but like, let's do this again because this was helpful. Is there any quick, like just recap tips to the agents if they find out like, oh, go ahead. Somebody else.
No, I didn't mean to cut you off. So I do want to make one more point, because this is important. If you are selling, if there is a property that is being sold during the probate process, it is possible to get, if you need to petition the court for authority to sell the property, it is possible to get that order signed within 30 days, the typical window to close. But it is very important that the personal representative's attorney is notified immediately and provided a copy of the sales contract so that they can petition the court immediately upon a contract being signed. There's a lot of different moving parts, but it is possible to get the authorization to sell it and close on time, so long as the attorney knows about the contract and can do everything that needs to be done within that time frame.
To follow up with what she was saying, though, sometimes the person that signs the contract isn't the person who should be signing the contract.
Right.
So from the title side, and then, you have to have an addendum, but sometimes it's not even that, because then the person who has the right to sign the contract is like, well, I thought the house should be more than that. It becomes the whole thing. So I strongly suggest, because it is all about timing, and you are dealing with the timing of the courts, as she was just saying. Yeah, the 30 days and all of that. You're dealing with the courts, and they move it how they move, So I strongly suggest for agents to pull title right away and get that process working. I mean, it's not always the case, but we have had a couple of situations where the person wanting to sign wasn't the one who should have been signing to start with.
And then that screws things up. So that happened before too. The wrong person signed, and then they had to start the process over again.
And you're starting over again.
Yeah.
And then you have a buyer that you're hoping is going to hang in there. And then, buyers too, which you can understand, they get a little shaky, like, what's going on? They don't know who's supposed to sign the contract. It just gets a little. So whatever the listing agent can do ahead of time to really make sure that they understand that it is going to be time intensive typically, and get in front of it and understand that they can have title pulled ahead of time and kind of guide their clients, and speak to, just guide their client being. And sometimes, the heirs, once that affidavit of heirs comes out, it's not just, two sisters. One sister may have died who has 5 kids. Now the affidavit of heirs are the 2 sisters and the 5 kids. And, it's a lot. And we didn't get into all that, but, it can be a lot more than what, the listing agent might think initially.
And that's awesome that you guys provide that service as a title company,
Yes.
to do that ahead of time, because not all title companies do.
And we'll do that. Yeah. We'll do that for any agent, for any property. If you're worried, a lot of times too, we'll do this, there's a divorce situation and they think, oh my gosh, the husband, we think there might be, we'll pull title for anything.
One last question before we jump off. One more question. What is the process when the deceased has a mortgage? How the beneficiaries pay the mortgage from the deceased funds instead of their own funds?
So this one's a tricky question, because that's going to depend on the whether it's a homestead or not, partially, but also I typically want the client, if possible, to be paying the mortgage out of pocket and reimburse them from the estate at the end.
You're talking about the monthly payments.
Yes. You are not supposed to use non-exempt assets to pay for exempt assets. So if there's a bank account with $100,000 in it, that's typically not exempt. That's not going to be an exempt asset. And to use that money to pay off the mortgage on an exempt asset is you can find yourself in a bit of trouble if there's creditors, because you're using their money to pay off a property they can't attach their claim to. So that's something, if possible. And then if there's a life insurance policy, like that money can be used to pay it down, because life insurance is generally exempt from creditors' claims. But like I said, I generally try to have, if possible, have the personal representative or a beneficiary pay with their own money until the end of the probate, or at least until the end of the creditors period, where we can see if there's any outstanding bills that need to be paid before applying it to especially a non-exempt asset, or I'm sorry, an exempt asset.
I love these Friday chats.
All right.
Bye, Lauren. Thank you so much. Cassie, thank you. Have a great weekend,
See-
everybody.
See you.
Bye,
You guys are awesome.
everyone.
Bye.
Bye.